5 seconds to go. Start. These have been cited to urge that at the stage of considering an application for being released on regular bail, the individual role of each accused is not required to be considered when they were allegedly a part of an unlawful assembly and charged with offences punishable under Section 149 IPC. The present petitions have been strongly opposed by Mr. Siddharth Luthra, senior advocate appearing for the accused respondents, and learned counsel for the accused respondent. Learned counsel submitted that any delay in completing the trial cannot be attributed to the respondents, and the adjournments referred to by the learned trial judge in the order dated 23rd August 2022 were not on account of the respondents. In fact, the prosecution witness was available only on two dates for his cross examination, and only one date was taken by the accused Niaz Ahmed on medical grounds. He submitted that accused Waseem did not misuse the liberty granted to him by the High Court wide order dated 22nd August 2022, and when his bail order was set aside by this court on 14th October 2022 and remanded back to the High Court for passing a reasoned order, he had surrendered on time. The allegation that the respondents are involved in several other cases is also refuted by learned counsel stating that the accused Waseem is involved in only one other case besides the present one where he is on bail. The co-accused Nazim is also similarly stated to be involved in one other case, that is, the captioned case, along with Waseem besides the present case, namely criminal case number 214 of 2016, where he has been released on bail. As for the accused Aslam, it is stated that besides the present case, he is involved in CC number 214 of 16, CC number 129 of 20, and CC number 95 of 23. The accused is involved in one other case besides the present one. Learned counsel submitted that the appellant complainant himself is a well-known criminal of the area, having several cases registered against him, as also his two sons. The criminal history of the appellant complainant and his two deceased sons have been detailed in paras 19 to 21 of the counter affidavit. As per the respondents, the appellant complainant is involved in 10 criminal cases and his two deceased sons was involved in 21 criminal cases and was involved in two cases. Next, contending that bail once granted cannot be cancelled until there are supervening circumstances, and in the present case there are no such circumstances that require setting aside of the impugned orders. Learned counsel for the respondents supported the impugned orders and requested that the present appeals be dismissed. It was additionally submitted that even when the accused Waseem was released on bail, he had abided by the conditions of bail imposed on him and did not misuse the liberty in any manner. On merits, learned counsel for the respondents submitted that there was previous enmity between the parties, that three persons had been falsely introduced in the FIR against whom no case was made out, and after investigation their names were dropped from the charge sheet, that the prime eyewitnesses PW1, 2, 3 and 4 are related to the deceased, being their father, uncle, cousin, etc. Several loopholes in the prosecution version were sought to be highlighted by the learned counsel for the respondents relating to conducting the inquest of the deceased, the difference in the time between reporting the crime that took place on 19th May 2020 at 20:30 hours as against the time when the investigation had allegedly started. Stop.